Chapter 2, Pharmacy Law, Ethics, and Regulatory Agencies. The terms and definitions we will go through as we progress through this lecture. The practice of pharmacy is governed by a series of laws, regulations, and rules that are enforced by federal, state, and local governments. The practice of pharmacy is also subject to policies and procedures established by institutions and/or pharmacy management at each pharmacy site. The number of rules and regulations is staggering, and most of us cannot easily decipher the legal tangle of words. However, we are required to follow these rules and regulations. This chapter presents the most basic laws and regulations that pertain to pharmacy, pharmacists, and especially the technician. A good understanding of these laws is necessary to pass the PTCB, which you guys will be taking at the end of this program. More important, it's necessary to know your responsibilities when working in the pharmacy. We're going to go over a complete overview of the FDA and its history. The FDA was established in 1862 along with the U.S. Department of Agriculture. The FDA is the oldest consumer protection agency in the U.S. federal government. The FDA's Division of Chemistry consists of a staff from several disciplines, including chemists, physicians, veterinarians, pharmacists, microbiologists, and lawyers. Until 1901, the Division of Chemistry evaluated applications for new drugs for use in human or animals, food and color additives, medical devices, and infant formulas. The chief chemist in the Division of Chemistry at the time, Harvey Wiley, changed the direction of the division, establishing scientific authority by researching the effects of chemical preservatives used in the production of foods and drugs, exposing potential hazards in products, focusing on consumer safety, and eventually paving the way for government regulation. Inspectors in the department visited thousands of food and other manufacturing facilities each year. In 1901, it was renamed the Bureau of Chemistry. Wiley's efforts led to the first passage of major legislation, the Pure Food and Drug Act of 1906. In 1927, the agency changed its name to the Food, Drug, and Insecticide Administration, and in 1930, it was shortened to the FDA, the Food and Drug Administration. Since the FDA's founding, the agency has investigated the adulteration and misbranding of agricultural goods used for food and drugs. Hundreds of bills were introduced by Congress to establish standards to protect the health of consumers. Yet the FDA's ability to regulate and enforce these standards remain limited, leaving the primary control to the states. The laws varied widely from state to state. Meanwhile, horrible incidents continued to occur, which some of them were the deaths of 13 children, 9 babies in 1902 after they were injected with a tainted batch of tetanus diphtheria antitoxins. In June 1906, President Theodore Roosevelt signed the Pure Food and Drug Act of 1906, also known as the Wiley Act. This important act gave the government the power to administer and prohibit the interstate transport of unlawful food and drugs. Drugs had to meet the standards of strength, quality, purity that is established by the United States Pharmacopoeia, which we abbreviate as USP, and the National Formulary Guidelines, abbreviated as NF. Any variations from the guidelines had to be plainly listed on the product label. The label could not mislead the consumer, and all ingredients needed to be listed on the label. The law also prohibited the addition of any ingredients to a food that would substitute for the food, conceal damage, pose a health hazard, or constitute a filthy or decomposed substance. With a new presidential administration taking over in 1933 under Franklin D. Roosevelt, the FDA was able to change its authority to include both quality and identity standards for food and drugs, prohibition of false therapeutic claims for drugs, and coverage of cosmetics and medical devices. The FDA had the right to inspect factories and control the advertising of products. The FDA countered advertisements of drug claims by exposing the horrible but true results of certain drugs. For an example, an eyelash dye that blinded some women as a result of dangerous additives, A medication tonic made with radium as an additive was found to cause a slow and painful death for the user. In 1937, a Tennessee drug company advertised a new sulfanilamide elixir specifically intended for children. This toxic solvent was untested and more than 100 people died, mostly children. It was later determined that the solvent was similar to antifreeze, which is a fatal toxin to humans and animals. In 1938, Congress finally passed the Federal Food, Drug, and Cosmetic Act. The act required manufacturers to prove to the FDA that a drug was safe for use before marketing it. The manufacturers had to provide directions on the drug's label for its safe use. The act also mandated standards for food, set tolerances for certain poisonous substances, and authorized factory inspections. The FDA was given authority to enforce the standards just a few months after the passage of the act. The FDA determined that sulfa and other drugs required a prescription from physicians before they could be purchased. Clarification of what constituted a prescription drug versus an OTC drug was established in 1951 with the enactment of the Durham-Humphrey Act. Other laws passed in the 50s banned carcinogenic additives to foods. Before 1938, the Post Office Department and Federal Trade Commission were in charge of ensuring the safety of cosmetics and medical devices. After 1938, regulating cosmetics and medical devices became the responsibility of the FDA. However, in 1976, another disaster occurred when an in uterine device that claimed to prevent pregnancy caused serious injury to thousands of women. Only then did the 1976 Medical Device Amendment allow the FDA to regulate and approve these type of devices and to recall ineffective or dangerous devices. With continued consumer and political pressure, the FDA has influenced new laws such as the Orphan Drug Act, which was passed in 1938 and targeted all rare diseases. The ODA influenced expanded research and availability of new treatments for AIDS, cancer, and genetic diseases. An overview of those amendments will be presented in the following section. What is an act? An act is a statutory plan passed by Congress or any legislator that is called a bill, until it is enacted, at which point it becomes a law. An amendment is a change in the original act or law. And here is some well-known federal food and drug laws. I'm not going to read them off this list because we're going to go through all of them one by one. So in 1906, we already just talked about this, the Pure Food and Drug Act was one of the first laws enacted to stop the sale of inaccurately labeled drugs. All manufacturers were required to have truthful information on the label before selling. By 1912, international meetings were being held to curb the increase in trafficking of highly addictive substances. The International Opium Convention of 1912 was one of these meetings. Limitations on opium transport and recreational use were attempted. The Harrison Narcotics Act of 1940 was enacted in the United States in parallel with international treaties to curb the recreational use of opium. Individuals could no longer purchase opium without a prescription, and it became harder to obtain opium for non-medical purposes. The Harrison Narcotics Act required practitioner registration, documentation regarding prescriptions and dispensing, and implementation of restrictions regarding the importation, sale, and distribution of opium, cocoa leaves, and any derivative products. The 1938 Federal Food, Drug, and Cosmetic Act was enacted because the earlier Pure Food and Drug Act was not worded strictly enough and did not include cosmetics. Two important concepts introduced in this new act were adulteration and misbranding. All addictive substances were required to be labeled warning, may be habit forming. Adulteration deals with the preparation and or storage of a medication, mishandling of the food or drug that may cause injury or death to a consumer. This act described the exact labeling for products and defined misbranding and adulteration as illegal. It's really kind of important to think about that because we depend now on our medications that are available over the counter that they are going to work for what they say they are. But before 1938, anybody could put a drug out on the market and say, this thing will save your life, it'll cure this, it'll cure that, without any scientific evidence to support it. So very important to kind of think about, like, before 1938, you could take a drug and die and not even, think about it, because the FDA didn't regulate that at the time. The 1951 Durham-Humphrey Amendment added more instructions for drug companies and required the labeling caution. Federal law prohibits dispensing without a prescription. Under this amendment, certain drugs require a physician's order and supervision. This amendment also made the initial distinction between legend drugs and over-the-counter drugs. So legend drugs are prescription-only drugs. The Kefauver-Harrison amendments enacted in 1962 were groundbreaking in their attempts to ensure the safety and effectiveness of all new drugs on the U.S. market. The amendments gave the FDA specific authority to approve a manufacturer's marketing application before a drug could be made available for commercial use. Firms now had to prove safety and provide substantial evidence of effectiveness for the drug's intended use. The required evidence had to consist of adequate and well-controlled studies. The amendments helped establish rules of clinical drug investigation and required the informed consent of study subjects. The amendment also required that drug-related adverse events should be reported to the FDA. The regulation of prescription drug advertising was transferred from the FDA, or from the Federal Trade Commission, to the FDA, and the burden was put on the drug manufacturing companies to ensure quality as good manufacturing practice standards were established. One example of the effectiveness of the FDA is illustrated by its role in preventing the sale of thalidomide in the United States. In Europe, people were taking this medication to help them sleep. In the early 60s, European women who had taken this while pregnant gave birth to children with severe defects, including the absence of limbs. The FDA postponed approving this drug until just before the birth defects across Europe were reported. Very few cases were reported in America. Those reported were due to women obtaining this drug from outside the United States. The 1970 Comprehensive Drug Abuse Prevention and Control Act, also known as the Controlled Substance Act, the Drug Enforcement Administration was formed to enforce the laws concerning controlled substances and their distribution. A stair-step schedule of controlled substances were introduced based on the drug's intended medical use, the propensity of a drug to be abused, and safety and dependency concerns. The 5-level stair-step schedule of controlled substances requires stricter rules for low-numbered classifications and less strict rules for high-numbered categories. Schedule 1 is the most restrictive and is defined as drugs with no medically accepted use in the United States. The prescription of a Schedule 5 drug is less restricted and requires less documentation than a Schedule 2 drug. The 1970 Poison Prevention Packaging Act required manufacturers and pharmacies to place all medications in containers with childproof caps or packaging. This includes both OTC and legend drugs. The standard specifies that medication should not be able to be opened by at least 80% of children under the age of 5, and that at least 90% of adults should be able to open the medication within 5 minutes. Exceptions to this act included physician requests for non-child-proof caps for their patient, certain legend medications, hospitalized patients, or a special request by the patient. Before the implementation of this act, there were hundreds of unintentional deaths of children under the age of 5 as a result of ingestion or other drugs or household chemicals. The first attempt to prevent these tragedies was the Hazardous Substance Labeling Act of 1960. Pharmacist Homer George of Mississippi was the driving force behind the first National Poison Prevention Week, occurring yearly in March. This list is exempt drugs that do not have to be childproof. And you can see that I have highlighted sublingual forms of nitroglycerin. That's a really important one to remember. In a hospital, they don't need to be dispensed childproof because the patient's not taking them on their own. The nurse is giving them to them. The 1972 Drug Listing Act, the NDC, was implemented under the authority of the FDA. Every drug has a unique 10-digit number divided into 3 segments. The numbers identify the labeler, product, and trade package size. The first set of numbers is the labeler code. So you can see right here, here's the labeler code. So that is all assigned by the FDA, and every drug that a drug company makes should have the same labeler code. The second is the product code, which identifies the product. You can see that's right here. The third set of numbers is the package code. It identifies the specifics of the package size and types. Both are set by the drug company. And here's just some more information about the NDC that you can read about. The 1983 Orphan Drug Act, we kind of already talked about this earlier, but the important thing to remember from here is that before this became, in 1983, those high-risk diseases like AIDS and genetic diseases and cancer, drug companies weren't making those medications because they would spend millions of dollars and many years of clinical trials to treat a disease that only affected a small portion of the population. Therefore, regulatory restrictions were waived for diseases that affected fewer than 200,000 people in the U.S. In addition, the Act encouraged manufacturers to develop drugs for rare diseases by providing marketing exclusivity for orphan drugs for a period of 7 years after FDA approval. The 1987 Prescription Drug Marketing Act addressed issues related to the distribution and wholesale pedigree of human prescription drugs. The intent of the act was to solidify the legal supply channel of prescription drugs from manufacturers to authorized distributors and wholesalers. The act helps prevent counterfeit drugs and ingredients in the supply chain and limits the diversion of pharmaceutical samples and prescription drugs. The 1990 Omnibus Budget Reconciliation Act, the origins of this date to 1987 when Congress addressed the problems regarding healthcare quality for the elderly. OBRA 87 set requirements for facilities participating in Medicare and Medicaid programs and addressed enforcement mechanisms. A minimum standard of care was required and a change began to take place, transitioning nursing homes from uncomfortable institutions to comfortable home-like environments that provide higher quality care. However, this provision did not address individual privacy rights. So the 1990 Act affected the responsibilities of practicing pharmacists and healthcare personnel in general. The Act outlines specifics for pharmacies to participate in the Medicaid drug rebate program. OBRA 90 also requires drug utilization evaluation. The intent of a DUE under OBRA 90 is to ensure that all medications being prescribed to patients would be reviewed for appropriateness. 3 important provisions of OBRA 90 include evaluation of drug therapy, review of drug therapy, and the DUE board review. In addition, the DUE must include systems such as computer programs that alert the pharmacist to possible drug interactions, precautions, and other pertinent information that the patient should know. OBRA 90 is specific to Medicaid coverage. Pharmacies usually now counsel all patients on medications that have been prescribed. That's how it started, was just Medicaid patients. If these provisions are not met, the pharmacy cannot receive federal reimbursement for medication and may face civil liability proceedings. The Board of Pharmacy in each state oversees OBRA 90 compliance. It can also impose fines on both pharmacies and pharmacists for noncompliance, although a patient may refuse counseling. The 1996 Health Insurance Portability and Accountability Act brought HIPAA and protected health information into the healthcare world. HIPAA's privacy rules are meant to protect certain health information. Standards of PHI address the use and disclosure of an individual's health information. Entities that are covered by PHI are obligated to comply with all requirements in the rules of HIPAA, which became effective in 2003. A HIPAA-covered entity is a healthcare provider, a health plan, or a healthcare clearinghouse. This includes entities that process non-standard health information they receive from another entity into a standard format. All covered physicians were required to update their HIPAA policies and procedures and otherwise implement the changes required by these regulations, no later than September 23rd, 2013 compliance date. Patient confidentiality is another aspect of ethical work. The definition of confidentiality is to keep privileged information about a customer from being disclosed without his or her consent. This includes information that may be embarrassing or harmful to the patient. Under federal law, patients have the right to privacy concerning their medications, treatment, or any aspect of their health care. These laws affect all areas of medicine, including pharmacy, concerning issues of obtaining, transferring, and assessing patient information. A patient's approval is required for the release of any information about the patient to any third party, including insurance companies, physicians, and pharmacists. Because pharmacy technicians and other healthcare professionals have access to information about a patient's condition, medications, and other personal information, they are responsible for keeping that patient's information confidential. What is protected? It protects all individually identifiable health information held or transmitted by a covered entity or its business associate in any form or media, whether electronic, paper, or oral. What does this mean for the pharmacy? Patient information must be communicated on a need-to-know basis with the provision that the entity is covered under the HIPAA health information rules and regulations. This means the physician can call and request information about his or her patient. The patient's health insurance company can request information on the patient, and the pharmacist can share with the patient about his or her own coverage or medications. How is this information protected on the computer? Several safeguards help protect electronically transmitted patient information. The sender of the PHI is required to use encryption to convert the information into a non-readable format. Decryption is the reverse process. The encryption technology must be approved by the National Institute of Standards and Technology to ensure its effectiveness in protecting patients' rights. Under HIPAA, the patients have the following rights: the right to ask and obtain a copy of their health records, the right to have corrections made to their health information, the right to receive a notice that tells them how their health care information is used, the right to decide whether they want to give their permission before their health information can be used or shared for certain purposes, such as marketing, the right to obtain a report on when and why their health information was shared for certain purposes. If patients believe that their rights are being denied or their health information is not being protected, they can file a complaint with their provider or health insurer. They can file a complaint with the U.S. government. They can either authorize or not authorize any sharing of their personal and medical information, and they can change or rescind their permission at any time that they desire. The HIPAA privacy rules specifically permit certain persons identified by the patient, such as spouse, family members, or friends, to receive information that is directly relevant to the patient's care or the patient's payment for health care. If the patient is present or is otherwise available before the disclosure and has the capacity to make healthcare decision, the covered entity may discuss this information with the family and these other individuals if the patient agrees to it. When given the opportunity, does not object. For example, when a person comes to the pharmacy and requests to pick up a prescription on behalf of an individual, he or she identifies by name. A pharmacist, based on professional judgment and experience with common practice, may allow the person to do so. So you'll see that a lot in retail pharmacy. Husbands and wives picking up each other's prescriptions, daughters or sons picking up, family members, relatives, even neighbors. So it is not illegal to just give someone their prescription if they have the right identifying information. So as a pharmacy technician, you cannot do the following: offer any personal or medical information pertaining to the patient to any entity not covered under HIPAA rules and regulations, share any information with any family member or friend, coworker, manager, or any entity not covered under the HIPAA rules and regulations. So what does that mean? That means that you can't go home and tell your family about what happened at work with a certain patient. You can't share patients' names with anybody. You can't even tell your family if you've seen people at the pharmacy, because that is actually a HIPAA violation. So for instance, here's an example. When I worked in a hospital, I delivered meds to patients' rooms, and my grandma's friend was in the hospital. And of course, when I seen it was her, I was delivering the meds to her, we started talking or whatever. Well, then my grandma asked me like a week later, how come you didn't tell me that she was in the hospital? And I was like, well, I actually can't tell you that. So, yeah, you don't want to share any information with your family member or friends. I know it's nice to vent about your day, but don't give any identifying information, medication information, or anything like that. Another thing is you cannot look up your own health information. So if you work at a hospital, every stroke you make on your computer is watched and tallied. So you cannot look at your personal record. You cannot look at your family members' records, your neighbors, whatever. That also goes for retail. In retail world, you cannot, if you work at Walgreens, you cannot get on the computer and look up celebrities. People have done that before and been fired. So everything you do in pharmacy is watched. So don't try to do anything that could get you in trouble. Through my years in pharmacy, I've seen more people fired for HIPAA violations than really anything else besides theft, I'd say. So box 2.4, you can read about some examples of breaching confidentiality. If you work as a pharmacy technician for a health plan or covered healthcare provider, the HIPAA privacy rule does not apply to your employment records, and it does protect your health records or medical records if you're a patient of the provider or a member of the health plan. Covered entities may disclose PHI to the following: public health authorities authorized by law to collect or receive such information for preventing or controlling a disease, entities subject to FDA regulations regarding FDA regulated products or activities for purposes such as an adverse event reporting, individuals who may have contracted or been exposed to a disease when notification is authorized by law, and employers regarding employees for information concerning a work-related injury or illness. The next 6 rules are rules that we can follow for law enforcement officials for them to obtain PHI. So if they have a court order or by law, we have to. If we need to identify or locate a suspect, fugitive, material witness, or missing person in response to a local enforcement official's request for information about a victim or suspected victim of a crime, to alert law enforcement of a person's death if the covered entity suspects that criminal activity caused the death, when a covered entity believes that PHI is evidence of a crime that occurred on its premises, by a covered health care provider in a medical emergency not occurring on its premises when necessary to inform law enforcement about the nature of the crime, the location of the crime or crime victims, and the perpetrator of the crime. So here are some examples. Can I have my friend pick up my prescriptions for me? Yes, you can. The pharmacist or technician has to make a judgment call. And usually if somebody doesn't want people picking up their prescriptions, or if they've had trouble with maybe like a family member coming in and stealing their prescriptions, because that does happen, we usually will note that in their chart. If my daughter calls the pharmacy to ask about whether the medications are ready, can I tell her? Yes, but you cannot give her any information. So technically, if she asks what is ready, you can't tell her the names of it. I don't know the exact laws. I know when I worked in retail, if they knew the name of the medication, we could say yes or no. I don't know if that was a Walgreens law or a state law. I'm not 100% on that. If I cannot speak the language and a stranger offers to interpret the exchange between myself and the pharmacist, is this okay? Yes, as long as the patient does not object. If they don't want to, then obviously you definitely don't. Is a pharmacist permitted to have the customer acknowledge receipt of the notice by signing or initialing the logbook when picking up a prescription? Yes. The 2000 Drug Addiction Treatment Act permits physicians to prescribe controlled substances pre-approved by the DEA in Schedules 3, 4, and 5 to individuals suffering from opioid addiction for the purpose or maintenance of detoxification treatment. The 2003 Medicare Modernization Act. Medicare is a government-managed insurance program that provides assistance to people over the age of 65. In 2003, a major change took place for millions of Americans with the passage of the Medicare Modernization Act. The revision provided a drug discount card to beneficiaries with low incomes who require pharmacy company assistance for obtaining medication. The new program is administered under the Medicare Advantage program, which began in 2006. This allows Medicare participants to offset high drug costs, which should also reduce preventable hospitalizations resulting from lack of medication treatment. So before 2003, there was no plan for people over 65 that were on Medicare to obtain their medications. So this is when Medicare Part D and Medicare Advantage came out. So just in 2003, which was 19 years ago. The 2005 Combat Methamphetamine Epidemic Act. So until 2004, PSC, pseudoephedrine, was sold as an OTC decongestant, and it wasn't limited for purchase by the consumer. In 2005, Congress passed the Combat Methamphetamine Epidemic Act in response to this problem. The bill addressed all areas of the manufacturing, law enforcement regulations, and sale of this drug. Although PSC is still labeled as a non-controlled substance, the manufacture, distribution, and sale of this drug must follow strict guidelines. According to these guidelines, only a licensed pharmacist or technician may dispense, sell, or distribute this drug. 2 states, Oregon and Mississippi, along with 63 Missouri counties and cities, now require a prescription for PSE products. The maximum amount sold may not exceed 3.6 grams in a calendar day, or 9 grams per 30 days retail, and 7.5 grams per 30 days via mail. You have to take the customer's ID, and depending on the technology at your pharmacy, you might just scan their ID, or you might have to fill everything out in a logbook. This chart lists additional pharmacy-related laws: the 1967 Fair Packaging and Labeling Act, the 1972 Drug Listing Act, the 1990 Anabolic Steroids Control Act, the 1990 Humanitarian Device Exemption Safe Medical Devices Act, the 1990 Nutrition Labeling and Education Act, the 1994 Dietary Supplement Health and Education Act, 1997 Food and Drug Administration Modernization Act, and 2010 Combat Methamphetamine Enhancement Act of 2010. In 2010, President Obama signed into law the Patient Protection and Affordable Care Act. This comprehensive healthcare reform makes preventative care more accessible and affordable for many Americans. The ACA has a number of provisions that will be phased in over a period of years, beginning in 2010 and continuing through 2020. The law requires insurance companies to cover all applicants with the new minimum standards, including individuals with pre-existing conditions. In November 2013, President Obama signed into law a bill that gives the FDA greater oversight of bulk pharmaceutical compounding and enhances the agency's ability to track drugs through the distribution process. This legislation was prompted by the deadly fungal meningitis outbreak in the fall of 2012 that resulted from unsanitary conditions at a compound facility in Massachusetts. 2 government agencies that are important in the practice of pharmacy. As you know, the FDA, we've been talking about it quite a bit, and the DEA. The main function of the FDA is to enforce the guidelines for manufacturers to ensure the safety and effectiveness of medications. To prevent misbranding, manufacturers must meet the following packaging standards under the Federal Food, Drug, and Cosmetic Act. And here's some examples of misleading information on the product label. The other department is the DEA. It was created later under the Department of Justice. The function of them is to prevent illegal distribution and misuse of controlled substances. The DEA also licenses to practitioners, pharmacies, and manufacturers of controlled substances. Their primary role is to enforce the nation's federal drug laws. The FDA has a toll-free number for reporting any defect found in OTC medications or any drug problem noted by a person. A technician or pharmacist can also use this number to report any problems with OTC or prescription drugs. The FDA does not typically order recalls, but instead may request in writing a recall by the manufacturer. Only if the manufacturer refuses and there's clear evidence of a risk to human health may the FDA enforce such a request. So here is a sample recall notification. There are 3 classes of recalls. Class 1, the highest level of recalls, it deals with products that could cause serious harm or death. Class 2, the next level, which deals with products found to cause a temporary health problem or pose a slight threat to serious harm. Class 3, the lowest level, which is used for products that may have a minor defect or other condition that would not harm the patient, but that prevents the drugs from being resold. Controlled substances such as barbiturates, opioids, benzodiazepines, and central nervous system stimulants are substances that are addictive and have the potential to be abused. Opioids such as codeine and morphine are substances created from opium and are addictive. When consumed over time, a person can build up a tolerance to their effects and require increased doses. Each type of controlled substance is assigned a rating that depends on its addictive and abuse potential. So we talked about that earlier in the chapter. This is an example of a labeled narcotic. You can see that on all narcotics, they have right on the front of them that they're controlled and then what class they're in. So this is a C2. The letter C means controlled substance and is used in addition to Roman numerals to indicate the addictiveness and abuse potential. In 1970, we just already talked about that. They established the 5 levels of controls based on the potential for abuse. So here's some typical controlled substances. So C1 medications are not approved for medical use. So you will never have those in the pharmacy. That's going to be your LSD, cocaine, mescaline, or heroin. In the C2 category, those are going to be in your safe at the pharmacy more than likely. And they are the most controlled medications and the most addictive, high potential for abuse. So you can see we have everything on there: meperidine, fentanyl, oxycodone, morphine, amphetamines, methadone, opium, and hydrocodone. Hydrocodone's pretty new to this list, and I think we'll talk about it in a minute, but that happened since I've been in pharmacy. C3, we have the Tylenols 2, 3, and 4. That's a good example. C4, anti-anxiety medications like Valium, Ativan, Xanax, Telwin, Librium, Delmane. C5, we have Lomotil, which is for diarrhea, Robitussin AC for cough, and Phenergan with codeine for cough. Okay, here it is. Effective October 6th, hydrocodone combination products are considered Schedule II under the Controlled Substances Act. The U.S. Attorney General has authority to decide under which schedule a drug should be placed. This decision is made after careful consideration of the scientific findings and recommendations from various authorities on the dependency potential for each agent. Many states have changed to a new type of prescription for controlled substances. These new prescriptions have up to 8 different tamper-proof security marks on them. And box 2.7 has some information on tamper-proof features. Here's an example in all the different places where it has the watermarks and stuff on it. The DEA uses 3 main registration forms in the regulation of controlled substances. Only Form 224 is needed to dispense controlled substances by the pharmacy. The following is a list of form numbers issued by the DEA along with their additional requirements. So to manufacture or distribute controlled substances, we need the Form 225. To manage a controlled substance treatment program or compound controlled substances, Form 363. Again, to dispense controlled substances, Form 224. To order or transfer Schedule II substances, Form 222. Authorization to destroy, damage, outdated, or unwanted controlled substances, Form 41. Retail pharmacies can only request this form once a year, but hospital pharmacies can request a blanket destruction form, which allows them to destroy multiple times throughout the year. Retail pharmacies that want to engage in wholesale distribution of bulk quantities of drugs containing PSE and other drugs must register with the DEA Form 510. For loss or theft of a controlled substance, Form 106. That also includes if there's a theft in the pharmacy by an employee, if there's a robbery, we have to let the DEA know everything that we do with our controlled substances. The DEA guidelines for C2 substances allow physicians to write up to 3 separate prescriptions at one time for multiple drugs to be filled sequentially over 90 days. The date of each subsequent prescription must be written on the order, and the prescription cannot be filled before the date. Each state's Board of Pharmacy may implement additional guidelines that control the amount of controlled substances that can be refilled. Most states limit refills of Schedule 3 through 5 to a maximum of 5 times or within 6 months from the original order, whichever comes first. A pharmacy has 2 ways to obtain Schedule 2 controlled substances from a distributor. They can do electronic or paper filing of a DEA Form 222. It must be signed by the pharmacist who signed the Form 224 or a person who has been legally assigned power of attorney by the pharmacist. The triplicate form must be completed only with a pen, a typewriter, or pencil. The top copy or copy 1 and the middle copy or copy 2 with the carbon paper are sent to the supplier or manufacturer by the pharmacy receiving and ordering the drugs. When the medication is shipped to the pharmacy, the middle DEA copy is forwarded to the DEA to prove that the medication has been properly received. When the pharmacy receives the controlled substances, the pharmacist compares the pharmacy's copy of Form 222 with the invoice and signs and dates both. The invoice and the form are stapled together and retained for 2 years. A pharmacy has 3 methods of filling controlled substances and legend drugs. So when we take in prescriptions and we fill them, we don't just like get rid of the prescriptions. We have to hold on to them for, I think it's a minimum of 2 years. And once the most recent ones are usually stored in the pharmacy, so they're easily accessible. But older ones are usually moved to a stock room with like a box label with numbers in case you need to go back in them. And I will tell you what, in my 15 years of being in pharmacy, there's been many times where I had to dig through old prescription boxes to find a prescription for a audit or something else. So there's 3 methods. They can use System 1, which has a separate drawer for C2s, another drawer for C3 through 5, and another drawer for all other prescriptions, which is how every pharmacy I've worked at has done System 1. System 2, they can do a C2 separate drawer and then a drawer for all remaining other drugs. And System 3, they can do a drawer for all controlled substances and then a drawer for all other prescriptions. Narcotics are at high risk for drug diversion and must be inventoried differently from normal non-scheduled drugs. The pharmacy maintains a perpetual inventory of these medications. This means that once the inventory is started, it does not end. Instead, it continues until the drug is no longer stocked. The term reverse distributor indicates all controlled substances that are unwanted, unusable, or outdated are returned to the distributor. If a controlled substance becomes outdated or damaged, the pharmacy must return the substance to the manufacturer or return the substance to a company that collects controlled substances, and then either returns them to the manufacturers or arranges for their disposal. So if you're like working at a mom and pop type pharmacy, the pharmacist can't just be like, I'm going to take these expired drugs home. We're not going to use them. Obviously, that cannot happen. It has to be sent away to be disposed of. And that goes with any prescription medication. To destroy medication, you need the DEA Form 41. This is determined by an agent of the DEA who instructs the applicant how to proceed. The following must be included on the form. Schedule 2 through 5 prescription drugs can be accepted by the pharmacy in written, oral, or fax form according to certain DEA provisions and or circumstances. A Schedule 2 order may be called or faxed ahead of time, but the original prescription signed by the prescriber must be presented before it is actually dispensed. Although the following regulations are outlined according to the DEA, each state normally has additional restrictions that must be followed. You can visit nabp.net and you can look up your state's Board of Pharmacy website. For refilling prescriptions according to DEA regulations, controlled substances are placed in 3 categories: C2, 3, 4, and 5. Schedule 2 cannot be refilled. Schedule 3 through 4 up to 5 times. Some states also C5 can only be filled up to 5 times within 6 months. Other states, it can be refilled as often as prescribed. When filling these drugs, the pharmacist must put on the back of the prescription their initials, refill date, the amount of drug that is filled. In addition, the pharmacy might use a data processing system to store and retrieve C2 through 5 prescription refill information. Schedule 3, 4, and 5 drugs may be partially filled if the pharmacist does not have enough in stock. The pharmacist must note on the prescription the amount filled, and the remaining amount must be dispensed within 6 months. Schedule 2 drugs may be partially filled if the pharmacist does not have the full quantity in stock. The pharmacist must note on the prescription the amount filled, and the remaining amount may be dispensed within 72 hours of the first fill. If it cannot be filled within 72 hours, the pharmacist must notify the prescribing physician because no further quantity may be supplied after this time. So just an example, if we wouldn't have someone's controlled substance, a C2 narcotic, they'd be like, well, I'd be like, we only have 5. Well, can I have those 5? You can, but if the medication for any reason doesn't come in the next day or within those 72 hours, you lose your whole prescription. Anything remaining is void and they have to get a new prescription. Schedule 3, 4, and 5 can be transferred to another pharmacy one time only. Schedule 2 cannot be transferred, but all the other schedules can be transferred one time. One thing to keep in mind is if a patient's on vacation in another state or city, if they have like 4 refills on the medication and they're on refill 2, that can actually not be transferred back to the original pharmacy when they get home. So that's always something to keep in mind when you have someone call the pharmacy who's either from out of state or from a different area. They cannot be transferred back. So they would have to either go back to that pharmacy or they would have to have their doctor call in a new prescription to their current pharmacy. In some states, Schedule 5 drugs are sold over the counter and they can be dispensed by a pharmacist. So here are the guidelines. I've never worked at a pharmacy that does this. Lending or transferring, a pharmacy may lend scheduled drugs to another pharmacy as long as the following guidelines are met. So here's the guidelines. I never seen this happen except for when I worked at Walgreens and it was from different pharmacies, but I don't know how that really would work if you were a small pharmacy wanting to borrow from another small pharmacy. I mean, here's the rules, but I don't know. I've never had that happen. You can mail controlled substances as long as it is mailed in a container that is not marked with the contents and information. Under the FDA labeling regulations, the following information must be available in monographs, also known as package inserts or official prescribing information. Physicians often refer to this information as published in the physician's desk reference book. It is also available for free online, such as the National Library of Medicine's daily website, which provides files from the FDA database. The following is the type of information contained in a package insert: FDA monograph information, prescription drug labeling. To be safe and effective, it has to be informative and accurate, use language that is not promotional in tone, false or misleading, not make claims or suggest uses for drugs, and contain information based whenever possible on data derived from human experience. The information on prescription drug labeling is also referred to as the packaging insert, the professional labeling, or the prescribing information. The highlight section of the official prescribing information is approximately 1/2 page in length and provides a quick reference summary of the most important information about the prescription drug. So highlights of the label cover the following topics and are cross-referenced to the corresponding full prescribing information. So I'm not going to read those now because we're going to go through every one. Number 1, indications and usage. You can find in this section the condition the drug is approved to treat, pharmacologic class of the drug, all limitations such as patients who should not use the drug, dosage and administration, so the recommended dosage regimen, range, the manner in which it should be administered, dosage forms and strengths, the section that lists all the dosage forms and strengths and provides identification information such as coloring and scoring. Contraindications, this bulleted section lists clear situations in which the drug should absolutely not be used. Warnings and precautions, this section is an abbreviated summary of the most clinically adverse reactions and actions to take when reactions occur. Adverse reactions, this section lists the most commonly occurring adverse reactions and the incidence of these effects. Separate listings are required for adverse reactions reported from clinical trials or from post-marketing experience. Drug interactions, both food and drug interactions are listed, as are instructions on how to prevent or lessen the interaction. Use in specific populations, so pregnant patients, patients in labor, pediatric patients, geriatrics, patients with renal impairment, patients with hepatic impairment, stuff like that. Drug abuse and dependence, if it has any potential to show tendency to become abuse, you can find that information. Overdosage, information on toxicity and the use of antidotes is provided in this section. An antidote is basically the reversal of the toxicity. Description, the section lists specifics about chemical agents and ingredients, such as the drug's chemical formula. Clinical pharmacology, this section describes how other drugs can interact with the medication and alerts the prescriber to adverse reactions. Non-clinical toxicology, this section contains information on studies conducted during the development of the drug, including in vitro studies, drug formulation, and in vivo efficiency studies. Clinical studies, this section summarizes the most important studies that establish the effectiveness and safety of the drug in humans. References, a list of reference materials that may be accessed for further information specific to the drug is presented in that section. How supplied and storage and handling, information about the medication is supplied. About how the medication is supplied is often given in a chart format because it lists the varying strengths, amount of drug per container, and dosage form, and whether the medication has any special requirements, such as protection from light or stored in a refrigerator. And then patient counseling information. This section includes suggested pertinent information about the drug that professionals should convey to their patients. The FDA-approved patient labeling is written for a lay audience. Even drugs given in the hospital by a healthcare professional may have patient counseling information. A box warning is encased in a bold border in the manufacturer's insert. Healthcare professionals often refer to these as black box warning, even though this is not the official name for the warning. This type of warning is required on medications and other products that carry a high risk potential for the consumer. So here is some special warnings and information and some examples of drugs requiring box warnings. Med guides are paper handouts that are available with many prescription medicines. Many medications with box warnings also come with med guides. Pregnancy categories. A pregnant woman's fetus is susceptible to the effects of drugs taken by the mother. The drug may be transmitted to the fetus during its developmental stages, causing birth defects. The FDA established 5 pregnancy categories that indicate the potential of a drug to cause fatal defects. The categories are based on the ratio of risks to benefits. So you can read through all of those here. Prescription regulation, who can prescribe? The FDA and DEA have no authority in determining prescribers. Physicians and other medical prescribers are licensed by their state boards, and the scope of practice is determined by their degree. In 12 states, nurse practitioners are allowed to prescribe medications independently, including controlled substances. Each state also regulates whether it will accept out-of-state prescriptions written by practitioners who are not licensed in the state. Individuals who can prescribe controlled substances may be registered as a mid-level practitioner with a DEA Form 224. In some states, pharmacists are granted prescribing privileges under a collaborative drug therapy management agreement. This agreement is between a physician and a pharmacist and entails the pharmacist to initiate, modify, and continue medication regimens. 5 other states allow pharmacists to obtain a DEA number. Who can receive a prescription? Clearly, a pharmacy technician takes in a prescription, enters and fills them. The pharmacist is responsible for interpreting and reviewing the information before dispensing the medication. Most states prohibit pharmacy technicians from taking orders for legend drugs, so prescription drugs. Often prescriptions are called, faxed, or transmitted by a computer from the physician's office by the physician or nurse. A pharmacist must translate any verbal orders into written form. Also, if a patient wants a prescription transferred to another pharmacy, this transaction must be done between licensed pharmacists or pharmacy interns under the supervision of a pharmacist. Any pharmacy intern can also receive prescriptions by phone. So just a couple things to talk about. First off, a pharmacy intern. These are not pharmacy technician interns. These are future pharmacist technicians. So they're in pharmacy school, like I think usually their last 2 years they're in these rounds, and they can do a lot of stuff under the supervision of a pharmacist. One thing I think you'll see is when I worked in pharmacy, it has been like 4 years since I've worked in an actual pharmacy, but we did transfers. In fact, we did most of them because the pharmacists were just too busy. And I always checked the voicemail and we always took in prescriptions. So I don't know what the exact state laws are from state to state. But I think in Michigan, where I am, they're a little lax on that, at least at every pharmacy I've ever worked at. So a prescriber's prescription order must have the name, address, and phone number, the license number, or the prescriber's DEA number if applicable, which means if it's a controlled substance, the date it was written, and the prescriber's signature. The label must have the name of pharmacy, address and phone number of the pharmacy, name of the prescriber, date the prescription was filled, prescription number, and any cautions described or provided on auxiliary labels. Certain drugs require that additional manufacturer provided information must be given to a patient because of the possibility of adverse effects from the medication. Interactions between food, drugs, or supplements and teratogenicity, which is genetic harm, to an unborn fetus. These instructions are known as patient package inserts and are distributed by the prescriber or the pharmacy dispensing the medication or device. So these are drugs requiring additional information: estrogens, fertility drugs, injectable contraceptives, oral contraceptives, and retinoids. Hospitals and community pharmacies differ in the length of time records must be kept. Record keeping is regulated by state law. Here's required prescription information between hospital, community, and home health care. Unit dose medication that is prepared in the pharmacy requires the following record keeping rules. Technicians traditionally prepare most of the unit dose medications in a pharmacy setting. The pharmacist then verifies the prescriptions, except in states that allow tech check tech. So on these repackaging, we should have the drug name, trade and generic, strength, dosage form, manufacturer, lot number, and expiration number. All prescribers must be registered with the DEA to write prescriptions for controlled substances. When approved, they're giving a 9-character identification code. This code is different for each prescriber. The first 2 characters are composed of letters. It can either be, the first letter can either be A, B, or F. So A, B, or F for any kind of doctor. Medical doctor, MD, DO, doctor of osteopathic medicine, podiatrist, a foot doctor, a chiropractor, a dentist, anything that's a doctor, their DEA can only start with A, B, or F. M is for nurse practitioners, which it says here, and also physician's assistants. X is for prescribers who are qualified to treat opioid addiction. We talked about that earlier. All right. Hospital physicians are also assigned an internal code that is attached to their DEA registration number. This information must be kept by the institution for verification purposes. So it would just be like the little last 3 numbers after the hospital's DEA. Most medications are required to be packaged in containers that are exceptionally difficult for children to open. Hence, child-proof caps were created. So we've already talked about this. There are some exceptions. Again, here they are. The book does like to repeat itself. Special prescribing programs. Methadone is a Schedule II controlled substance and is used to treat individuals addicted to opiates. Patients are to receive specialized treatment when taking this medication. No more than 1 day's supply may be refilled by a pharmacy, and the medication must be taken into a physician's office or drug treatment center. Other brand names for methadone include Delafine and Methadose. Although methadone is more commonly used to treat opioid addiction, it can also be prescribed by patients with appropriate DEA registration as an analgesic to treat chronic pain and to alleviate pain in cancer patients. So this medication is really, it's just really awful that they still let it be prescribed for pain. The one thing about it is patients have died. I've actually known a few people that have overdosed on methadone, and a friend that died in high school from overdosing on methadone. It's a pain medication that makes you think that that you need to take more, but it's building up in your body over time, so it can be kind of bad in that sense. Suboxone and Subutex, they're sublingual tablets. They're going to go under your tongue, are Schedule III controlled substance that requires special consent forms to be completed by the patient. When the prescriber has met all conditions, the DEA issues him or her a special number with an X identifying the doctor as a qualified prescriber, which we've already talked about. So this here is the verification process for a prescriber's Drug Enforcement Administration number. So you can go through the procedural steps. So verify that the first letter of the number is A, B, F, or M. Determine whether the second letter is the first letter of the prescriber's last name, in this case, J for Johnson. Use this formula. First, add the first, third, and fifth numbers. So they have an example here. Continue. Second, add the second, fourth, and sixth numbers, and then multiply by 2. So they have that example. Complete the formula. Finally, add the two sums together. Compare the results. If the last digit from your total matches the last number in the DEA set, the number is valid. The FDA Amendment Act of 2007 gave them the authority to require a risk evaluation and mitigation strategy from manufacturers to ensure that the benefits of a drug or biological product outweigh its risks. Certain drugs are placed in a restricted status for use. The FDA regulates isotretinoin, Accutane, amnestine, Clavaris, and Sotret, those are all the brand names, under a special program called iPledge because of the serious adverse effects of this drug. It causes birth defects, therefore it is important that female users understand they may need to take precautions to avoid becoming pregnant. In addition, possible side effects of suicidal thoughts and signs of depression are now associated with this drug. This agent requires a box warning. iPledge is a computer-based risk management program designed to increase awareness of the dangers of isotretinoin in an effort to eliminate fetal exposure to the drug. There are restricted distribution guidelines that must be followed before a patient can receive a prescription for isotretinoin. In 2010, the National Drug Control Strategy was implemented due to the surge of prescription drug abuse and heroin addiction among adults. The NIDA lists more than 23 million over age 12 with an addiction to some type of illicit drug or alcohol. That is really a crazy number. The NABP PMP Interconnect, developed by the National Board of Pharmacy, is an interstate data system used to share prescription information and provides a more efficient means of combating drug diversion and drug abuse nationwide. The National Take Back Initiative, established by the DEA, allows safe, responsible, and convenient way for the public to dispose of unwanted drugs. The term brick and mortar refers to a building such as a retail pharmacy. A common practice is to mail medications through the post office or other authorized mailing system. Online pharmacies such as e-pharmacies in the 1990s, they began to appear on the internet, which led to the opportunity for drugs to be ordered illegally. In addition, consumers could be defrauded because some e-pharmacies charge credit cards but do not mail the drugs. Although verification is done by the NABP, the organization does not regulate the sites. Instead, the websites are regulated by the state in which the pharmacy is physically located, along with federal guidelines. E-pharmacies have the same regulations as retail and mail order pharmacies with regard to dispensing to out-of-state pharmacy locations, and they are also required to adhere to HIPAA regulations. There are many advantages to ordering medications via the web, including ease of ordering, lower prices, and easy accessibility to online information, which lessens the wait time when trying to ask a pharmacist for the information. However, identifying illegal pharmacies is a constant struggle for both state and federal agencies. If a suspicious e-pharmacy is found, it should be reported to the NABP. If the wrong medication or label is dispensed, this should also be reported to the state's Board of Pharmacy. Signs that a pharmacy site probably is illegal include the following: dispensing medications without having the customer mail in the prescription, faxing a prescription that cannot be confirmed as valid, dispensing medications upon completion of a questionnaire, not having a pre-existing examination or patient-prescriber relationship, inability to contact a pharmacist at the website for consultation. The purpose of the Occupational Safety and Health Administration, OSHA, is to make the workplace safe for employees. This box 2.11 presents an outline for common safety and health topics. A safe workplace involves having safe equipment, materials, being able to safely perform tasks, and ensuring that the policies and procedures of a company, including pharmacies, are safe. OSHA requires safety data sheets, information on all potentially dangerous chemicals used in the workplace. So here's some common safety and health topics. Almost all chemicals can be dangerous if ingested or spilled. In all workplaces, including pharmacies, all chemicals must have an SDS on file in an SDS binder, or the SDS must be available electronically through a database. These binders are normally bright yellow and black. In 1951, several medication associations created the Joint Commission on Accreditation of Healthcare Organizations as an independent nonprofit organization that voluntarily accreditates hospitals. In 2007, the JCAHO changed its branding to the Joint Commission. The Joint Commission meets 3 times annually and has 32 voting members, consisting of physicians, administrators, nurses, employers, a labor representative, health plan leaders, quality experts, educators, and a consumer advocate. TJC surveys all aspects of hospital services, including pharmacy services. Each state has its own set of laws that pharmacists, interns, and pharmacy technicians and clerk must follow when working in the pharmacy. You will notice that many states have laws that differ from federal law, and remember that the strictest law is the one you follow. Liabilities. You should also be aware of federal and state liability laws pertaining to pharmacy technicians. A patient can make various charges against a pharmacy technician if the pharmacy technician caused damage because of negligence or intentional action in the workplace. A tort is defined as the act causing injury to a person intentionally or because of negligence. The word negligence may describe an action taken without the forethought that should have been applied by a reasonable person of similar competency. A mistake was made. If you're involved or a witness in any incidents in the workplace, you should follow these guidelines, review your state's regulation, understand your employer's rules and practice, and define your scope of employment. If an event occurs in the pharmacy, you should be prepared in the following ways. Know the name of your attorney. Always be careful what you say and whom you say it to. If you're ever questioned by state or federal investigators, write down in-depth notes on the facts of events as soon as possible and keep them for reference. Hopefully you'll never have to do that. Ethics are the values and morals that are used within a profession. Morals are a person's beliefs concerning what is right or wrong in human behavior. The Pharmacy Technician Code of Ethics. Pharmacy technicians are healthcare professionals who assist pharmacists in providing the best possible care for patients. The principles of this code, which apply to pharmacy technicians working in any or all settings, are based on the application and support of the moral obligations that guide the pharmacy profession in relationships with patients, healthcare professionals, and society. So a pharmacy technician's first consideration is to ensure the health and safety of the patient. A pharmacy technician supports and promotes honesty and integrity in the profession. A pharmacy technician assists and supports the pharmacist in a safe environment. A pharmacy technician respects and values the abilities of pharmacists, colleagues, and other healthcare professionals. A pharmacy technician maintains competency in his or her practice and continually enhances his or her professional knowledge and expertise. A pharmacy technician respects and supports the patient's individuality, dignity, and confidentiality. A pharmacy technician respects the patient's records and discloses pertinent information only with proper authorization. A pharmacy technician never assists in dispensing, promoting, or distributing a medication or medical devices that are not of good quality. A pharmacy technician does not engage in any activity that will discredit the profession and will expose without fear or favor illegal or unethical conduct in the profession. A pharmacy technician associates with and engages in the support of organizations that promote the profession of pharmacy through the utilization and enhancement of pharmacy technicians. Professional ethics are systemic rules or principles governing right conduct. Each practitioner has the duty to adhere to the standards of ethical practice and conduct set by the profession. Pharmacy technicians have a responsibility to make informed decisions based on their specialized training. Professional codes of conduct must be followed. Respect is a key component of professional behavior in the pharmacy. Technicians should always display a sincere respect for the pharmacist, the patient, and their healthcare colleagues. Being honest, trustworthy, and an all-around team player demonstrates this professional ethics.